Well, good evening, everybody. Welcome to the April 8th, 2019 meeting of the Yellow Springs Planning Commission. Going to call the meeting to order. Start by calling the roll, please.
Indeed. Doden.
Here.
Stiles.
Here.
McQueen. Here. Williams.
Here.
Donnell.
Here.
Also present are Village Planning Administrator Denise Swinger, Village Solicitor Chris Connard, and present also for this go are Dino Pilata, our alternate, and Lisa Krieger, our council alternate.
All right, I'll just review the agenda, which is pretty light for the evening. We'll go over the minutes of the last meeting, the March 11th meeting. No communications. Mary Ann, will you have a council report?
Well, do you want to do the minutes?
Well, no, but I'm just wondering, are you going to
Oh,
have? Okay.
like a sentence.
Okay. Then we'll have citizen comments. We don't have any scheduled public hearings for tonight. 4 items of old business, nothing on new business, and then agenda planning. So, okay. Let's go over the minutes of March 11th, 2019 regular meeting. Just 2 pages. Are there any corrections or problems that anybody sees with the minutes, pages 1 or 2? Hearing none, I'll make a motion that we accept the minutes as written.
I second it.
All those in favor say aye.
Aye.
All opposed? Thank you. Okay, since there's no communications to report on, Mary Ann, you want to, the council report?
Yeah, my sentence.
Sure.
I think that the main thing was that the council passed on the second reading the PUD for Millworks. We also have brought transient guest lodging information and requests to Planning Commission to review and make recommendations back to council. There were some text amendments. Is that right, Denise? Was that adding the electric? I don't remember what they were,
Yes.
a bunch of.
To the planning code, yes.
Into the planning code, adding electric as one of the kind of utilities that's included with water and everything else.
I have a question. I think I had read this in the paper. I didn't see wasn't at the council meeting nor watched the YouTube of it. When they approved approved Millworks, was one of the conditions, I think they took off what was it, 30%? But the things that they can sell, they all have to be made by the artists or the companies that are there. They can't bring outside things in and sell. Okay,
Yeah.
I wanted to be sure on that.
Yeah, they weren't allowed to do general retail.
Great.
Any other questions about council report? Okay, thank you. All right, now we'll open the floor for citizen comments on anything that's not on the agenda for tonight.
A question I have. Okay, so for citizens, things that are on old business, can there be citizens' comments? There can. Okay, just not a public hearing. Okay.
Seeing no citizen comments, I guess we'll close the citizen comment period. No public hearing scheduled for tonight, right?
No, no public hearing.
Zipping through things here. Go on to the 4 items that we have under old business. Review of planning code subdivision regulations, review of planning commission duties in the planning code, review of BZA duties in the planning code, and review of transient guest lodging legislation. Just go through these top to bottom.
Okay.
Yeah.
As far as subdivision regulations go, I wanted to look at the subdivision regulations because you know, we have these two potential subdivisions that are gonna be coming before planning commission at some point. And they were just, you know, it hadn't been updated since the 1990s. So I wanted to just have a conversation with planning commission about it tonight. When I looked at, one of the things in there that is a little, could be problematic, I think, I don't know, is that both the preliminary approval and the final approval goes through planning commission and council. And I just don't know what happens if you have a council that would change, you know, between the time the election is and then, you know, a new council comes on in January. When I looked at, like, City of Beaver Creek, they don't even have council involved in it at all. The planning commission actually signs off on everything. So I thought, well, you know, maybe we would do something or consider something like with the preliminary, or like how you do the PUD, where you have council, you know, an approval of the preliminary, allowing planning commission maybe to come back in detail with the finals. So that was one thing I noticed.
Excuse me. But the council does, on PUD, does do it twice.
Not the final plan. What they did the other night was the rezoning and the
Right,
they approved the preliminary plan and the rezoning. But when the PUD comes back for final plan approval, it doesn't go to council.
I see.
So that was one thing I thought could be a little problematic. And I also feel, you know, in looking at other communities' subdivision regulations, they really have a lot more information in there about stormwater design and, you know, and I feel if we're gonna move in a direction where we're gonna do some of these new design elements with the new urban design elements, that we maybe need to get the subdivision regulations up to that. Right now, we are required to, it states in there with water and sewer and storm that we follow Greene County subdivision regulations. But in meeting with Devin Shoemaker of Greene County Regional Planning and also with Ken Middleton with the soil and water, I mean, they are, you know, realize that theirs are as outdated as ours. And they're in the process of doing some amendments to their code. And, and of course, said to us, we have home rule regardless, so, and we're willing to write a letter to that effect. So I would prefer, at the very least, is to have a civil engineer look at this too, and see if our subdivision regulations, where we're lacking and what we need to do. I mean, I know we have to have Ohio Department of Transportation's approval process. If you're within so many feet of a public road, just in case they have some long-range plans. But when I look at City of Beaver Creek, they give ODOT up to 120 days to respond back, which I'm thinking is a long time. So I don't know if that's also a requirement. Ours are very minimal. And I think that for developers, they may need to have more information. So I don't know what anybody thinks about that.
So your first, you, I think we're sort of maybe recommending that council not be involved in approving the final plan, was that?
I think that's something we should discuss. I mean, it's not, I'm just saying it could
Well,
be, I could see it as an issue.
And so, just for me to be clear, 'cause I'm not sure I'm understanding, I'm assuming it's that you would have a council and the commission are in support of a subdivision. And so it goes through the commission, and then it goes to council and they approve it. And let's say they approve it. And then the council changes, and you have some new members who don't like what's being done. And the concern is that it would come back for a vote, and maybe they would vote it down. And you have this developer who has put out all this money for trying to develop this plan, which they thought was what would be approved by the village, and then it's not.
There is definitely that scenario.
Okay.
The other scenario would be that maybe they wouldn't be allowed to vote because they didn't have they weren't involved in the
Ah.
information at the first time, and you might have to start back again. I don't know.
The preliminary plan is the document that's approved in concept and conditions. That goes to council for their blessing. When it comes back for final plan review, it's a compliance issue that staff dictates whether or not it meets compliance or not. If it doesn't meet compliance, it's got to go back to planning commission for further review, and then council then must recommend if that's okay, if there's a major deviation. But if it's within the concept, staff has authority and planning commission has authority to approve it. And it does, so,
But in this, I'm not reading it that way.
What,
I'm-
you can
I'm
point us to
read-
the-
yeah, let
the
me-
other section.
On final plats.
What number?
Yeah, 122604. Submission of an action on final plats. And then let's see, where's the voting at?
It does say for final action by planning commission
Under
and
A.
council.
that's a plat. A plat is different than, a plat is the actual deeded document that describes all of the lot lines and covenants and restrictions, so it can be recorded at the county level.
Right, but you have the preliminary plat, maybe said it wrong. You have the preliminary plat that you have to get planning commission and council approval on, and then you come back after that with the final plat that you have to get planning commission and council approval on again. I just don't know that there needs to be council again. I mean,
Well, anytime that you have, a plat is different than a concept plan for a development, for a subdivision.
okay,
The plat is the legal binding deed document that goes for recording. So that's why council signs off on it by vote. And it's on Mylar, it's certified by the engineer, and that's part of the deed. The plat doesn't really go into all of the other things, like the stormwater calculations and all of that stuff.
But it talks about that, number 2.
so, okay, so maybe
Says
I'm
10
just not-
copies of construction drawings, including profiles of streets,
Preliminary plat
sewer,
section.
storm, water,
02.
gutters.
And
Yeah, that's the final development plan.
kind of the same.
What page is that, Mary Ann?
That's the next page. It's,
What page?
well, it's 5.
Five.
It's at the top of 5.
Yeah, because the process for preliminary plats is pages 2 to 3.
And this is the final, under final plat. And under D, it does show the village council holding a public hearing and then voting.
So I guess in my mind, and because I've not been through the subdivision process yet, well, not like we've done that very much in Yellow Springs, but to me, it was like you had the preliminary and you divided out according to what the requirements were for that district, the lots and the roads and showing the storm and all that. And then that had to go through the approval process. But then you came back for the final plat. after you've done some more steps, like you had to put the monument rather than, up, and a few more things that are required in the design. And then that comes again for an approval process.
Okay, you got the same process twice,
Yeah.
basically.
I don't know.
But it can be clarified then, if that's the case, then it can be clarified that the preliminary plat plan or development plan is where the content and discussion is about conditions. The second phase for the developer is compliance to those conditions. That requires all the calculations, all of the survey records, all of that kind of stuff, which is very technically oriented toward a staff level. And so then somebody has to sign off and says that, yes, staff did in fact look at that, and we all approved that it is compliant to the preliminary plat recommendation. That's the way I would see it go.
Okay, it just seemed like they had all these other things. If you look at 122605, that once the preliminary was approved, then the final plat has to contain everything that obviously the preliminary plat had, plus there's these additional things then that has to be done. So, at an additional cost to the developer that, then it could get kind of, I
And
don't
it
know.
does look-
Maybe
if
I'm
you look
overreading
Well,
this.
I think that the challenge here is that in subsection D
Oh,
Yes.
of 122604 includes, since it has, council will take the action to approve with conditions, or disapprove. The reality is that it's hard to imagine that if a developer has gone and you've gotten past that preliminary stage with conditions, if you're going there for the final, it would seem to me there would have to be an extraordinary set of circumstances for disapproval. Now, that would be in the purview of council by definition of what council can and can't do. And so having it stated in there has some logic. But I think to Denise's point, when I looked at this, and we had a very, very general discussion and did not dig
We
into.
did not dig into it.
We did not dig into it, because one of the things is that the village is now undertaking some exploration of what could be substantial development in the residential front, which would require some subdivisions, and these regs were written in 91. The only change that has been made related to trees back in 2017. And I think that the question of staff is, given what we see in the future, should we go back and look at these subdivision regulations because of their age to say, do these still fit with the vision of the village? I mean, you're also going through now your comprehensive plan revision, and I think that you really want to try and get those things, which you all recognize as parallel as possible. So I think that's really what the broader-based discussion is, not the meat and potato of the process.
Well, these, in my mind, these planning, the planning code in general was written around a suburban model for growth. And when Greene County redoes their model is going to be written around suburban growth. We, as a community that can dictate our own regulations for design constraints and things like that, can override that county spec, except to the point, I think, except to conditions of subgrade conditions, how much weight, composition of asphalt, those kinds of things. But not necessarily design elements. How we choose to deal with our stormwater is on us. How we choose to design our streetscapes is on us. But we got to put the roadbed down, we got to put so much gravel around the water line, we got to use certain ductile strength for the water line, certain types of hydrants, et cetera. Those, to me, are county specs, but not village specs.
So taking off of what Chris said, would it make sense for us to have someone who understands, or who we tell the kind of things that we want to have, or our values, I guess, in terms of subdivisions, look at it and make recommendations for change?
I think, we have our zoning, which is really for that. I think, I was just more concerned to make sure that, you know, when we're digging down into the stormwater, the layout of the streets and those kind of things match our values and such.
I have another, I guess, question. Because we had a housing needs assessment done, which shows that there is an incredible need for workforce housing, affordable housing. And I'm wondering if this should be a place, because I don't know where else, where we are asking a developer or telling a developer that we would like a certain percentage of the development to be affordable. You don't think it would be
No.
here? Where would it be?
Well, I'm working on that. I mean,
My
hasn't come to council yet, but I've been talking with consultants.
And would it be something that would happen in a subdivision?
Well, we've talked about having voluntary inclusionary zone. And what John Davis, the person I was most recently talking to, said, and he referred me to another place in California that's doing this, is they do it on a project-by-project basis. So, I don't know whether that would, to me, it doesn't seem like that would be appropriate to put in this document. I don't know, but,
My concern is that, you know, where do we put it? If this is a need that the village has
in our
spoken.
housing plan.
Yes,
Well,
that has
in your
spoken very
comprehensive
strongly.
plan, certainly it's going to be in the comprehensive plan as the baseline of what puts people on notice of this is what the community standard is, and you expect that to be met, because that's something that you consider in any review. That's implicit in everything that you do, not just what the legal standards are set forth in the code. And then I think Mary Ann, I know, has been looking into it, and that's an evolving discussion.
But the housing plan, which we have just started, that would be, it would be in that.
And how would that then interact with this? I guess I'm not clear on that.
Particular, I
Well,
don't know how.
You know, my concern is that we're gonna be having some new development, and these may be, who knows, you know, we don't have a lot of land left to develop. And so our opportunity is now, if we're gonna respond to the citizens who are wanting affordable housing, workforce housing. And I don't wanna see us miss it by having developments occur, and that they've been like ones in the past where they just don't pay any attention to that.
So, from a subdivision regulation standpoint, you know, we have what's in the zoning code is what they're following as far as lot sizes and that kind of thing. I think, as we just said, on a case-by-case basis, you can negotiate density with the developer, and those are negotiating things that you can say, we will give you more density if you do more of this or that. But ultimately, you're gonna file that subdivision, and unless the developer builds it, it's just a paper subdivision. And they could end up completely pulling out later and not doing any of that. And then you're kind of starting over again. So I think it really is, obviously, if you negotiate with the subdivider, with the developer, but let's say they go away, you still, your real tool is the zoning code. Because then as stuff comes in, whether it's, you know, someone else coming in and doing it, I think it might be through the zoning code. I don't know, what does anybody else think about that?
I mean, I guess to your point, what's written in the PUD legislation does address giving benefits for
Yes.
affordable housing.
Yeah, but that wasn't a subdivision of land, that was just like, you know, a zoning thing where
Yes.
you're coming with your idea
Yes.
and this is what you wanna do.
Well, I actually think Denise, it's one of the things Denise was getting at when she said that she had a concern about this coming back in the final plan to council. Because if I'm understanding you correctly, your concern there is that they can have a chilling effect on the developer. If they get clear to that point and realize that council's a political body, the political body might have turned over in November, and now the people they thought might have been in favor of passing through this, that they may no longer be, that simply if that language is there, it could have a chilling effect on a developer who might otherwise be interested in coming in and making a proposal. And then that further to your point is that affordable housing is not the only very high-ranking village goal. It's also, we have goals around sustainability, goals around energy efficiency, and somehow, all of those have to get in here without making it too impossible for a developer to come in and build that. And so it's an incredibly delicate balance, which is why I think that the more philosophical, political desire for a particular kind of housing is properly placed in the comp plan to say, okay, now, you have heard us, Planning Commission, make sure that there are no chilling effects in the zoning code, and understand our desires when you go about looking at those plans. But I think that the more specific your language in the zoning code, the more chilling the effect on the developer.
Anybody else have any thoughts on that? Because I understand what you're saying, I really do.
So,
I think that there should be, what you can do is make a reference to a document and ask the developer how they comply with the document itself. So the housing needs assessment, the question can be asked of them, how do you see fulfilling what the intent of that document is doing for our community? And, because I tend to disagree about what the interpretation of that is. I think that there is a high rate for affordable. There is also asking for a lot of market rate too.
Oh, I agree.
So when you go and cherry pick one segment, what you get is imbalanced development. And when you get imbalanced development, it throws the market niche into a tizzy on how to get that balance in other areas that may not exist.
But I don't think that there is an imbalance with market rate. Market rate will always prevail and has in communities. It is the affordable housing that is really hard to bring about. And we're seeing it in development all around. The development that's been going on within the village, single-family houses going up. It's rare that any are affordable. And, my concern is, I agree, we need market rate. I went to several of the community meetings and heard that strongly, but I heard just as strongly, and the report showed just as strongly, that there are many people who are working in Yellow Springs and can't afford to buy a house in town and want to.
I know of no community that has a glut of affordable housing, other than unless you want to go to Dayton or Springfield, where they have abandoned houses that are, well, some of them are in okay condition, but only disinvested communities have a glut of affordable housing. That's not us.
we try to bring us back
Yes.
to, to the request that you had in your letter. It seems like, from what everybody's been saying, that there's kind of two issues that you're looking for some sort of resolution on. The voting process and the role of council in voting process on the preliminary and the final plotting. And then the section, basically the section that starts 12/22/06.
Are these
The design
standards up to date?
What sort of thing, if you want to look over it starts on page 6, it's 1226.06, the design standards. Because when I was reading through that, I was seeing, the language about, runoff and are those the sorts of things that we would need to list
Yeah.
as, what things do we need to identify as stuff that might need to be updated
Like
or
the
improved
state
upon?
streets.
Yeah,
the
I've
frontage
seen some
on
subdivision regulations that actually have like a a type of design for the stormwater, how they want to see the calculations for the runoff. I mean, they get that detailed, but. So the design standard, are the design standards up to date? The two-part voting process, and the stormwater. And I'd just maybe like to have, perhaps the engineering group that's doing our stormwater study could actually look at this. Have them look at it and give us their input.
I mean, I've got red lines all over this document. So I'm not sure exactly where this, what you're asking, I guess.
Oh, maybe just sort of a list of those red line things. When you say red lines, things that you're going, what is this doing in here?
Yes.
Or- Okay.
Yeah,
Well,
Yeah, and I had a
it's-
lot of things that I was questioning, like, is this up to date? Is this current? Are we
Yeah.
still doing this? Yeah.
these are very antiquated, and I think even the, my goodness, the throwback to what the county standards are non-existent because the county doesn't have standards. There's a reference to our thoroughfare plan. We don't have a thoroughfare plan. But the thoroughfare plan is basically the document that would describe street width, where those streets, you
and
know.
what we consider to be our arterial roads versus
Yes.
our collector and our local,
Right.
yeah.
Yeah. You know, so in my mind, those are things that are significant.
Yeah.
I think the way that it's filed, you know, doing electronic filing, how that relates to our new comprehensive plan, eventually to the zoning code, how those documents are done is really the way to get the filing. Or at least ask for that in addition to the way they're.
So if I could ask everyone who has these kind of red line questions or thoughts about it, if you could just email that to me with your, and then I can incorporate those into something that I can,
Okay.
share
And
with
what?
the civil engineer and
Well,
have him
is
look
it
at
a
it too.
simple engineer that we want to have? I mean, it seems to me we want to have it as holistic as possible.
Well, this is just one stab at it. I mean, we'll come back for.
Well,
the
and it also
other things.
depends on the civil engineer.
Yeah.
Well, I mean, given that we are going to have at least one subdivision, it seems to me important to have this be as up-to-date as possible and reflect our values as much as possible. So I don't know if there's one firm that could look at this and make recommendations for it, as opposed to send it here and then send it here and then, I mean.
Well, I
Yeah, I
think
don't
any
know, I'm
firm could do that if they understood the intent of what our policies want to be to change the
Any
document.
civil engineering firm? Is
Yeah.
that-
Yeah, I mean, you know, there's a lot of difference between, some engineers are really heavy on doing stormwater piping. Curbs and gutters, stormwater pipes, that is the way that they manage stormwater. There are other firms that are a little more sustainable that talk about bioswales, low-impact design standards, I think is probably the word that you want to put in here. You know, we really are a community that values low-impact design standards.
And I agree with that, because I think everything I'm reading about that, you know, to being able to, not just have this stormwater that goes through pipes and heads right to our creek, but actually has an opportunity to filter through naturally, the bioswales, and by the time it does get to the creek and is discharged, it's not as polluted as it would have been just coming from running asphalt into storm drains, is definitely would be something the community would place value on. So how do we get this all, how do we incorporate that somehow into this? But yet, we want to make sure, at the same time, that how that's calculated, it doesn't cause a subdivision problem for when you have a 50-year rain or a
Well,
100-year rain, or.
any subdivision has to go through that process of having an engineer certify the stormwater calculations, and that's based on a state code and mandate. It's not a county.
Okay.
It's literally a state
And is that
mandate.
state code, does it take into consideration calculations then for bioswales and
Yeah,
different
it
things.
doesn't, yeah. The engineer determines how much a bioswale can absorb, detain, or retain based on its plant material or its base. Those calculations from a property-to-property calculation then take a plat, and whatever is left from that goes into a detention or retention pond as a part of the plat design.
Okay. All
You know,
right.
I think personally that if we can get our baseline of what requirements are, low-impact design requirements are done on a plat level, then we can kind of work on our residential code and talk about individual lots detaining a little bit of water, using rain garden concepts and having some educational tools to help residents understand that.
Yeah.
That would fit into that low-impact
Yeah,
philosophy.
because that is a concern, and Johnny had expressed that,
Yeah.
you know, as we do this infill and we split these lots, we have to, whatever we have, we need to also be able to have it at that level too.
Yes.
So next steps, if you can maybe give me your thoughts, email me your thoughts on a direction, and do you want me to bring it back to you, or?
Well, procedurally, if recommendations are made to amend the code, then it would need to be approved by planning. So I think that get council or the commission's input, take that, and then staff takes it to the next level, which ultimately will come back with another report and recommendations to the planning
Yeah,
commission.
okay.
There were a couple other things that I think ought to be considered, real quickly. And it goes back to, some things to talk about incentives. You know, for development, this would be a good opportunity to put incentives into a document. You know, you get, incentives for density, you know, incentives for low-impact design, for public gathering spaces, looking at new urban concepts around prioritizing the pedestrian bicyclist as opposed to the car. That is a concept, you know, for design. The engineer needs to know that going into it, because if he focuses on the automobile first, you know what you get. Traffic calming and density, things like that. Use of alleys.
I mean, would you see that just in the general planning code? I mean, as one of the planning code chapters? Like, there would be a stormwater management chapter and not in the subdivision regulations, but in the planning as its own separate thing?
I
Or-
think that every code section has an intent to begin the section. And in that intent, what is our intent for welcoming new development?
Yeah.
And, you know, that goes to
I
affordable
kind of feel it
housing.
almost needs its own chapter. I mean,
Yeah,
it
I mean,
really
it could-
does.
Or
Yeah.
a sentence, yeah, I mean, at least.
Okay, all right. All right, well, if everybody gets that into me, we'll just keep
Okay.
moving forward with it.
Can you summarize, you mentioned the incentives, but you said there were a couple other points. So can you just kind of distill the points that you think that staff ought to take into account
Yeah.
in a general sense?
Said traffic calming.
Well, those were part of the incentives to development.
Yeah, and incentives are, you know, if you have a general code, there isn't any value statement in them, right? Affordable housing is a similar thing. Energy efficiency those are in the zoning code. But there's nothing in the planning code that talks about the layout of streets. That's the difference of the line, I think.
So you would like to see something that has, and I'm going to use the word preamble, but a statement of values and purpose,
Yes,
community standards.
yes.
Okay.
You know, something where, you know, Ryan Holmes reads that intent statement and says, well, we're not gonna
You'd like
mess with that one,
in
right?
Here, like at the beginning of the design standards
Yes.
section.
Yes.
Okay.
The other one that I would say is that we need to define what major and minor subdivisions are a little better than what they are, I think, in the definition side.
Well, I
Right
would,
now, it's just minor is
Well-
5 or less.
well, I would note that
Lots.
that in the Ohio Revised Code, while generally section 711, .01 has remained constant, there were changes in the definition, plat definitions, that
okay.
appear to have been done in 2009 and 2010. I haven't done a comparison, but again, I just, let's track all of this, and I
Okay,
think
yeah.
we get something back to planning.
Yeah. All right, well, maybe Ted, you just turn that in to me and I
Okay.
can
Just
review
email-
it. and-
Email you
yeah.
that stuff?
Yep,
Okay.
email me that stuff. Okay.
Any other questions or concerns about this first?
So we're gonna get comments to you, and then you are what?
I'm gonna take those comments, put them into a
Distill.
report, and spit them right back at you. So we'll go over it again.
And then after that, I'm assuming it
After growth.
goes to a civil engineer. and their
Well, at some
engineer.
point in there, I would wanna have them, like, for the stormwater section especially, yeah.
I think that'll allow us to have a more focused discussion than we're able to have tonight, once we have everybody's ideas sort of put into a report. Make sense?
Yep, yep,
Everybody happy with that?
okay.
All right. Let's go on then to the second item under old business, the review of planning commission duties in the planning code, which, is your letter on that? Is that page?
All right, so, let me just kind of summarize here.
Your second letter in here?
Okay, so we had a Board of Zoning Appeals meeting not too long ago, and we've been having difficulty getting attendance. And so we ended up having two regular members and one alternate at the meeting. The request was just for a variance to the size of a sign, and the vote was 2-1. So then it became a question of, well, in the zoning code, and actually the person who voted no said, well, if the charter says something different, then, then it can pass. But in the BZA code, it says 3 concurring members, just as it does in the planning code. But if you go to the charter, it says the majority of the quorum, and a quorum is 3. So we thought when we were, to go and do a charter revision is a big task, although they are planning to do that at some point here soon. However, is this something that we just want to make consistent with the charter? And that, at least with the Board of Zoning Appeals, it says a quorum is 3, the majority of the quorum makes, so it passes with the majority of the quorum. On the Planning Commission side, it doesn't say anything, it's silent. So how would you interpret that in the charter?
Well, the issue that came up is since there were only 3 people present at the BZA, and it was a 2-1 vote, whether or not, because the planning commission would have required 3 votes to approve it. So there
As well.
there was this issue, and Denise and Judy called me right away. We looked at the charter, and the charter addressed it, thankfully. And then did some research to confirm that, not a surprise, but there's a body of law out there that makes it very clear. The charter trumps the code. So the charter, which makes perfect sense. But anyway, in the context of that, we realized that we had this anomaly. The existence of the anomaly isn't necessarily a bad thing, but it was a surprise when we discovered it. And so the question, it seems to me, is, first, is there value in uniformity so that we don't have these issues that come up for people in the future who wouldn't necessarily be aware of it when all of us are no longer serving the village? Or is there a logical reason why we might have these different standards that maybe staff hasn't thought of? Because I confess that I kind of struggle why we would require 3 votes of planning commission if we only have a quorum of 3, and it would otherwise be a majority vote for everything else.
To me, it seems like it would only be a case of such severity that you want to demonstrate that you have that many people that support it.
Agreed. And when would
But
those come up? I mean, you know.
Or you said only like an emergency super vote or something.
Well,
for-
let's just create our own hypothetical. Hypothetical that we have some type of PUD application in front of the body, that 2 members of the planning commission and the alternate have to recuse themselves, so we only have 3. And that would require, under the current code, a unanimous vote. But nowhere else in our code does it require that, and it seems to me to be contrary to what the charter says, but interestingly enough, the charter only addresses BZA and not planning commission. And now, I don't think that we have to go and do, and I would not necessarily suggest that we would do a charter amendment. I think we can do it at the code level. It's just easier, cleaner, and so anyway, I think that we wanted to bring it to the planning commission's attention. And if you, as a body, felt that we should prepare a staff report on the subject with a recommendation, we would do that.
And it's interesting, in the boards and commissions, it says a majority of current members constitutes the quorum, so if it's 5, it's 3, and then you just have to have a vote of a concurring vote of a majority of that quorum. Now, when you get down to the planning commission for conditional use requirements, it's concurring. You have to have 3 concurring votes. Now, I've never had a situation since I've been here where we didn't have 4 or 5 members anyway, so it never mattered. And I've never really seen a split vote on a conditional use. So, but like you said, do we want to be consistent with the charter?
Wait, when you say consistent with the charter,
Meaning the majority of the members constitutes the quorum.
for BZA, and then you would make that consistent, but it's silent with planning commission. You're saying you want to make planning commission consistent with BZA?
Correct.
Correct. Well, no. Planning commission and BZA in the zoning code are 3 concurring members.
For planning commission for certain kinds of votes.
Yeah, and same with BZA for variances. 3 concurring members. It's in the charter that it's a quorum, and it's the majority of the quorum. And let's see, if you look at my, I have Exhibit B under that, and Exhibit So Exhibit B says a concurring vote of 3 planning commission members. Under Board of Zoning Appeals, it does say the presence of 3 members, I'm sorry, shall constitute a quorum. But then it says the concurring vote of 3 members of the Board of Zoning, of the board shall be necessary basically to reverse the zoning administrators.
But that's BZA.
Yeah.
Right, I think the point is, the real issue comes down to this, that within our planning commission, it says that a concurring vote of 3 planning commission members shall be necessary to take any action authorized by the code. That does not comport with what the charter says vis-à-vis BZA. It does not comport with other aspects of what the planning commission would do, and it doesn't take into account the possibility that there could be recusals, which could take the body down to 3, and then it would have to be a unanimous vote. And that doesn't seem to make sense.
It does not make sense. I think it should match BZA.
And I think,
But okay, please look at Exhibit C for BZA, because I'm seeing under 127801, it says the presence of 3 members shall constitute a quorum. However, if you go to the last page of that, number B, that I highlighted, it requires the concurring vote of 3 members in order to reverse the decision of the zoning administrator saying, this, doesn't meet our code. So in other words, it's contradicting itself in the BZA code. So in both the BZA code and the planning code that's in, both the BZA and the planning commission that's in the zoning code, basically are saying 3 concurring members.
So that the conflict that exists
Yeah.
is that the charter
the
says
charter
the
says-
BZA can have 2 votes.
Yeah.
Right.
The planning commission says you must have 3, and then we have language within the code for the BZA that's inconsistent with the charter, which
Yeah.
is the reason you called me.
Right.
And it's really that simple.
Right.
Well, but
Then
so-
the last sentence there,
Oh,
the
in
last
B?
sentence, where it says abstentions or recusals will count as votes concurring with the majority of those voting if a majority exists. So it's sort of like,
I have a
well,
question
and
mark
that's, you could
beside
say
that as
like,
well.
okay, there are only 3 people, 2 voted yes, 1 voted no, so then all the abstentions go with the yes vote, and then you have 3.
Which is complete, well,
That's
lawlessness at that
bizarre.
point. I
That
have to
makes
say.
no sense.
Then all you need to do is recuse, and you
Right.
can stay politically above the fray. I mean, that's,
What? But
that's so
what it
not
says.
okay.
That makes no sense.
But I do think so that we get, let's get BZA off the table here. Let's figure that one out, because it's, right now, the charter states mandates what happens in BZA. So you either say, yes, let's make that section consistent with the charter, and you
So you
take
want me
it
to
off the
come back
table.
with consistent language for
Yes.
both BZA and PC,
Yes.
and planning
Yeah,
commission?
yeah, okay,
Yes,
wait,
please.
wait.
I think that's simple, because
But
we just
did
go-
you-
Yeah.
we get it. We're looking for consistent language when it comes to BZA. The charter's going to govern that. And I think that the spirit of what the charter says is what we want planning commission to mirror as well.
Correct.
That's what he's
Where I'm
saying,
at.
so,
Good job.
Nice.
the spirit of
So
it,
you'll
yeah.
come back with
charter
the staff
I
report.
like it.
No
No
charter
charter
change.
Continuity.
And are we also saying we want planning to be the same?
Yes.
Yes.
That's
Yes.
likely to be the
Yeah.
recommendation from staff.
Because- right,
If I
you
if I
come back with
could
a-
read the crystal ball, yes.
Yes.
So you'll be coming back with a staff report on that?
Yes.
Yeah.
Okay, good.
And that also takes care of BZA and planning together at the same
Right.
time,
Takes
so,
those
Okay,
two
wait a
middle
minute.
two
So are you
there.
gonna
I
address
do
the
have
recusal
something in
business?
that,
okay.
because when it, and
Right.
that's D, are we at
D
D,
what?
Exhibit D?
What section are you, exhibit D?
In the
Okay.
part that we're just going on, the
Okay, yeah.
planning commission.
Gotcha.
The
Well,
question,
planning.
the question I had is where it talks about, and Denise has highlighted alternate members. And are you gonna talk about that, Denise? Or have we, have you already covered that, you think?
Well, ironically, Judy and I talked about that today.
Let me see, where was
And
that at?
I'll summarize this.
Exhibit D.
Okay,
Okay.
the,
Other way. No.
one can read Exhibit C to say that if you're not present at all, you can't just review the video. Historically, what has happened is that, and I think that the alternate on the Planning Commission came to a couple meetings in the event there was a possible recusal, and also because that alternate wanted to be aware of what was happening. It seems in the age of technology, if we've got the videos, a alternate should be able to sit by watching that record because that reflects what had happened. There's no executive sessions, there's no anything that's mysterious, it's all transparent. So C was highlighted for that reason, and I think that we should just include a recommendation on that as well.
And I agree with that, and that's what I was
Right.
gonna say, because when I missed the 2 meetings, I watched the YouTube of it,
Right.
and I read the minutes, and I felt like I was as well informed as the people that were here. And so, and I thought that I had heard, maybe it was a council meeting or something where, I would ask the person to declare that they watched the video
Right,
and read the
we
minutes.
have,
and
that. We have people affirm that they
Yes, affirm,
reviewed
that's
the
it.
record, yes.
But that seems reasonable, that then they would be able to vote, because they do have a good understanding.
All right,
All right, I'll bring that back to you.
so we are then up to the review of the transient guest lodging legislation, is that right?
Yes.
May I interject? I would like to interject. It's my sense that both Ted and I should not be involved either. I don't know about the discussion, but certainly any vote.
Well, and that, Mary Ann, you're correct. That's because when the matter first became council, went to council in 2017, I got an ethics opinion from the Ohio Ethics Commission that concluded because, you have to be careful, I'm qualifying this statement. Transient guest lodging, because the village is so small, is not a pervasive enough business that it becomes a matter of general concern, the way it would be if you were voting on whether or not to raise the utility rates, for example, because everyone's impacted by that. So the decision is that if one were engaged in transient guest lodging as a business, then those would need to be recused. So Ted, that would affect you and Mary Ann. Sorry for that long-winded explanation.
So would we have the council alternate and another alternate. Should we ask them to come and be involved in this
Yes.
discussion?
I think that would be appropriate.
Great.
And we can sit in the room?
Y-
or
yeah,
should we
You
leave?
can, but certainly if you want to leave, you can watch the video, you can, however you want to handle it.
And there was a question raised about,
But we might need you for the agenda planning.
Was there something else?
Well, there's the agenda
Yeah.
planning, which is setting a date. Is that?
Well, do you want to just do the agenda planning now? I mean, there's no reason we can
Yeah.
just do the agenda
I don't think
planning.
we can
Come on,
absolutely decide
Ted.
on anything because I
We
don't
need
have my
ya.
school calendar in front of me, but.
Well, we can coordinate with Judy later on to confirm, but once you have those dates, and then that way if Ted and Mary Ann want to leave, they can.
Okay.
and Frank, did you want to ask about the document at this time that Mary Ann had submitted?
I want to ask about it.
Yeah, you had asked whether Planning Commission should in fact consider that document, which,
I had asked that? I don't
was it
think I asked.
you? Was it
Somebody
Ted?
else was there.
Somebody asked.
Somebody else.
One me.
I did.
Oh, I think,
Okay,
yeah, Ted
Ted.
was talking. Yeah.
Well, because Mary Ann is recusing herself from the discussion as a whole, there was a feeling that perhaps that document as a whole should be given back to perhaps the council alternate to say, can you put
Right.
your stamp on this document, change it in any way you see fit, bring it back to Planning Commission, so that Mary Ann's recusal is full and fair, basically. I mean, we all know, she stepped up and did that work when other people weren't there to do that work, so that is, it's certainly no judgment on the fact that she put a lot of hard work into it.
Right.
It's more about the perception of who's authoring that document and making that recommendation.
So were we looking at our calendars, or we're going to wait till the end to do that?
Okay, so I just,
Okay, look, why don't we,
you're
why don't
running
we,
the show,
why don't
so.
we, as long as we got you guys here, let's talk about the agenda planning, setting a date for the Kinney subdivision work session.
Are you guys ready to do
Yes.
that? You are, okay. So what staff would like to do is see if there's any time where we could, and we have to have time to publicly notice this, but we also have 314 Dayton Street that really needs to have a conversation at a work session level with Planning Commission.
That Union School?
Yes, and I would prefer if we could do something, I know this may not work for you, AJ, maybe you're a little more flexible, yeah.
Whatever it takes.
Yeah,
Just
so
get off
during the
Hey,
daytime,
For me, it
No,
just
work for the
depends on the
people.
day.
okay, because we want to have staff, Public Works, and it could be actually some foremen as well, that might be at this meeting. So we'd like to do something during the day. So if we threw out maybe a
A
couple.
range of days. or-
Yeah, a range of days, and then you can let
Okay.
us know. Well, what do you know that you're usually not teaching?
Just because, yeah, it's really hard to explain, but in the last week, I've picked up what amounts to 6 additional class meetings that are spread out over 6 days. That just sort of randomly appear.
Okay,
And so I do not have this in my head at all. I have it on my calendar at work, but I don't have it here. And some of them appear in the afternoon, some of them are in the morning, so for the remainder of the semester, my schedule has gotten a lot more complicated. So for me, there'll be some afternoons where I will be able to be available, but some that I won't be able to be available. But,
Okay.
but if we could shoot for, like, maybe having a few afternoon possibilities, then I can look at my schedule tomorrow and get back to you right away.
Okay, all right, well, that sounds good. So based on that,
And when you say afternoon, does that mean after 1 o'clock?
yeah.
Probably 1 o'clock and beyond.
Okay.
Is that all
So,
right?
yeah, and so I'm saying then that means if we put it in the paper the week of, beginning next week, the week of the 15th, it would go in the paper on the 18th. We have to have 10 days if there's, well, it's not really a public hearing yet, right? It's just a work
No,
session.
it's a work session, you're okay.
So I'd be okay if it just went in the paper and you can have it anytime the next week, the week of the 22nd.
No,
Second through the
Okay,
26th.
so
no,
No.
Okay.
I won't be.
Oh, you won't? Okay, I said,
So-
I have availability.
my first
the
open date's May 2nd,
May 2nd, okay.
and
May
any
2nd.
time after that.
Anytime after May 2nd,
I'm not available on Fridays,
okay.
but probably Thursday.
Does that include May 2nd? When you say anytime after May 2nd, or just we start?
It
May
includes
3rd,
May
it'd be-
2nd, but it's a trip back from China on May 1st, so
So
I
you
may
prefer May
not be
3rd
here
and beyond.
mentally.
Yeah, perhaps not a good idea.
No Fridays.
So no Fridays,
No, I'm not
so,
available on Thursdays.
okay.
So
All right,
Monday,
well,
Tuesday, or Wednesday
So,
afternoon.
so we're looking at,
Mondays,
okay, so May 7th, May 6th, 7th, 8th is a Monday, Tuesday, Wednesday?
Yep.
Everybody,
I'll look at those.
you'll look at
How
those?
many hours do you need for this, do you think?
Before you were saying you would give them 2 hours.
Yeah, I would not give that to the 314 Dayton. It doesn't need that. So I'm saying a range of maybe 2.5 to 3 hours.
So 1 to 4.
1 to 4, that's good. So 1 to 4 we'll leave open May 6th, May 7th, May 8th, and I will let you know. Is there anybody at conflict with that? May 6th, 7th, 8th, okay. With whatever Frank fits his schedule.
And I'll email you tomorrow morning.
Okay.
All right.
Is good on that? Can you
Yeah.
email me, or do you email me as soon as you get it, because then I can.
I'll try to remember you to.
Or Denise will let me know,
Yeah,
then I can pop it back out.
okay,
All right.
great.
Okay, thank you.
All right, okay, so transient guest lodging.
What's that?
Transient guest lodging, I guess.
Right.
We're back
no,
on that, yeah.
Transient guest lodging again.
See, for a second ago, I was like,
No.
no, no, no.
Oh, it's in, yeah. My pad died just as I. Found it.
Yeah, it's barely in. Can you feel it?
I think the record should reflect what a seamless transition this was.
Yeah.
Doesn't smell great either.
Everyone has, well, most everyone has read my report, and it was really just a historical reference of a little snapshot of where we're at right now with transit guest lodging, and what we had proposed previously to council for some amendments a couple years back. But Lisa, maybe you wanted to say where council is coming from now as to why this has come back to planning commission at this time?
Yeah, I didn't get a sense that there was a really strongly unified perspective from council. I think that's why council is really glad to have a discussion at this table, because there's kind of this range of, we're all reading things in the media almost every day about different communities that are really adding a lot of regulations and saying like, this is really concerning. So there's this kind of sense of concern about the way transient housing is changing communities. And then also this perspective, but that's not gonna happen here. and then trying to decide, should it become something that's a one-off? So every single time someone requests, is it a one-at-a-time thing? Or is it better to just make rules, and how draconian should they be? So, I mean, I think that we've talked about it a couple times, and every time we talk about it, I get the sense that we kind of go through that same loop, and then we're like, should go to planning, So I think that's about where it is now. I get a sense that people are open to a lot of ideas, open to the ideas of this body.
So, one of the things that I did get the sense with council was that they would be interested in at least making it a conditional use.
At least.
That the body, that an applicant does need to come back to, before planning commission. So, now, when I had brought it to planning commission a few years back, it was because, we didn't have anything in the conditional use requirements really to ask the applicant. And I wanted to try to keep it also consistent with what I thought with the accessory dwelling unit. And perhaps you don't need to re-ask the same questions if they've already gone through the accessory dwelling unit process, but there are a lot of accessory dwelling units that are out there that hadn't gone through that process. So we kind of catch it up that way as well, but that we might want to consider some of these other ideas that have been presented at the council level that we actually hadn't talked about before at planning commission level. And besides returning it as a conditional use, there were other suggestions of looking at it, where the owner lives on the property, or you could limit the number of establishments within like a residential zones, like so many in each residential area. If you, I mean, right now, you can have them in every district except industrial 1 and 2 and conservation. Although I don't even know if B2, there isn't anything in B2 that could be residential, so that was a little bit of a conflict. So, and one person said, why does it even matter in B1? I mean, how many there are. So, that's a possibility, or limit it to the permits to people who actually live within the village, even though they may not live in the house. So there's these other ideas floating around there.
I have a question about, and the things that you're talking about were in the letter from Patty Bates. And one of her points, I think the second point talks about that there are currently 33 establishments, to the best of their knowledge. 16 are owner occupied and 14 are not owner occupied. And I wondered, of those 14, because I think it was a small number of owners that lived outside of town.
Yeah, if you go to my report, it's more up to date on
You have
that.
that.
Yes, there are actually, at that writing, there's probably 41 now. There were 30, and we've just had 2 recent ones in the last couple,
And you-
at least last week or so.
Reduce the
And
number.
both of those were people that actually live on the property. They're just renting out rooms.
Yes, but I guess the question I had is, of the ones that are not owner
Yeah,
occupied.
so of the 39 that, in this report, when I was writing this report, there were 37 active applications, and I had to take out those ones that were
So
not.
37.
Yeah, so, and of those 37, you had to take out the Glen Helen's Outdoor Education Center and the Morgan House, B&B, and Mills Park. So that left a base of 34 locations. And of those 34, one had an application under one name for both a house and an accessory dwelling unit on the property. And the other one has like quite a few that were under that one property. So that leaves 32, and so out of those 32, 8 had separate mailing addresses. And of those 8, only three owners live within in the corporate limits. So out of those 32 properties, 5 live outside of the village, 4 live outside of the township.
Okay, the question I had about the properties, and I guess maybe it's the 8, I'm not sure what the number is, that are not owner occupied. I'm talking about the ones that are not owner occupied. So some of them are owned by people in town, some by people in the township, and some by people outside that area. I'm wondering how many properties do each of them own?
We're only dealing with the ones that are transient guest lodging.
No, I'm talking about how many of those guest lodgings belong to, like, does.
Is there like one
Yes,
person or
yes.
entity that owns
Is there one
several?
person in Yellow Springs that has 3 of them? Is there somebody in the township that has 3? I'm just sort of wanting to get, like, what is that balance?
Of those 8, 3 owners live, 3 owners, there was,
You said 3 owners live within the corporate limits.
yeah, I think they were all separate. They're all separate, I'm pretty sure.
Okay, so,
Yeah.
Nobody's owning multiple units.
No, that's not what I'm saying.
Oh,
I mean, nobody's living in a house and then has multiple
Right.
different ones spread out.
that they're
I mean,
renting out.
Yeah, I mean, there are people that live on a property and have an accessory dwelling unit in their house.
Right.
That maybe they're both renting
Okay,
out.
okay. Thank you.
I mean, there are people on this list that own other properties, but they're not using them as transient
Yeah,
guest
and I'm
lodging,
only
yeah.
asking about the
Yeah.
transient, yeah.
If I may, I prepared a PowerPoint presentation for the Miami Valley Regional Planning Group in last December on transient guest lodging. Patty has a copy. I've given one to Judy. And one of the slides that I'm looking at talks about defining your goals. And I haven't been to all the meetings, but I still sense that there's not been one consistent philosophy that's been put out there. And so on this slide, I've got define the goals. Is it to raise revenue? Is it because it impacts affordable housing? Are there other community considerations, which are really broad-based, but I'll get to that in a second. And then there's an economic impact, okay? Certainly one would argue that having, so I think out-of-town folks coming in probably has a positive economic impact. But when you start to look at some of the community considerations, if families are no longer living here because they can't, what impact does that have on the schools? At some point, you lose economies of scale. So what's the impact there? How does it impact the income tax? And the fabric of community. So for example, in Columbus, one of the things that they were having some significant problems with, and frankly in Cleveland too, there was collateral consequences of the transient group coming in and what they did to the fabric, not only of the neighborhood because they were in and out, but the noise, the complaints, the police response. When Jennifer and I were researching this project, I mean, some of the stories that would come out, I mean, granted, these were extreme examples, but the renting of the party house at Bel Air, even though it may have cost $2,500, $3,000, $5,000 a night, and they would just have these parties that destroyed these homes, and of course the neighbors don't want that. So it seems to me that at some point, if a decision is made that we are going to regulate this beyond something other than a conditional use, that we probably want to articulate what those reasons are, because if we want to restrict it, we have, not that we have to, but we are better off articulating that reason if there's a challenge at some point. And the court cases that we've read, and what seems to be the evolution, because this is still a fluctuating area of law, has been giving deference to the communities, whether it's under home rule or some other authority, but the belief is that the courts recognize that the councils in their communities know that community better and the values that they want to protect. So.
my struggle with it is, if you have this as a conditional use, and then you have neighbors that come and they don't want to see this next to them, and planning commission can deny that based on the neighbors.
That would be a factor, that would be a legitimate basis to consider for denying a conditional use application. And I'll tell you, I was actually surprised at how micromanaged some of these responses were. And again, I think that the courts are giving great deference to this because the courts recognize what the impact is. You know, certainly the idea of what the liquor license model is. You get a fixed number of licenses, and if one's not available, you don't get one. And then when one's available, if your name's on that waiting list, you're the next in line. What I would say is it's almost as if the limits of your imagination are the limits of what we can do. So in that context, it becomes very hard to say, this is it. So in some ways, I think that you have to find that starting place to say, okay, let's start with this.
Well, yeah, and maybe, because one of the questions, I'm not sure what page I'm on, but it's the other suggestions, number one, the return TGLs to conditional
yeah.
use. And I said, for me, my reaction to that description was that it seemed reasonable, but do the conditions that we would then apply have to be uniform for each applicant? And maybe you're getting at, when you're telling us that we need to articulate why we want to have restrictions, that would be the
And
language
this
that
gets
would
into the
require.
whole
Well,
thing about public
AJ's
input.
smiling.
I mean, in fairness to.
Right, I would be in support of conditional use, and then an application may be denied for reasons.
Okay.
And that's what we have.
And
And just may
articulate.
be denied for this list of reasons,
Right.
several of them being
Yeah.
in the staff report
So that
now.
everybody knows what
Right.
the possibilities are.
And they can kind of know their odds, and then if there's a public meeting and all their neighbors show up
Right.
and say, I don't want this, and they have a pretty good idea, this isn't gonna pass.
That's-
So
Right.
what I would say, Frank, is in response to your question, the law has to be applied in a uniform way, but each factual scenario behind a request is unique unto itself. And so as these
So my-
matters come forward, you can address those. And, you know, frankly, it's an evolving environment. If the village is having more problems, for example, because of police response to an Airbnb and it becoming more of a problem, or maybe it's in a specific neighborhood or a specific licensee, the village, through its planning commission, has the ability to address that, or frankly, the zoning administrator, because there's some remedial actions that could be taken to revoke somebody's license under certain circumstances.
So that gets back into the question of you have to have factual information. So is the next door neighbor's concern versus the person around the corner down the street stating something? At what point does,
Would you look at a saturation level of a zone, of an area, to see how much is in that area? I mean, that could be another litmus test of the saturation level is so much in that area. We know that we probably want to limit that area.
Denise, what you're talking about is often characterized as the weight of the evidence. And the weight of the evidence is something that the body, and typically a judge, but in this case, you're adjudicating facts, making decisions, each of you get to place what weight you want on that. And it may be credible, it may not be.
so is one of the pieces of information from staff could be what is already existing around there?
Well, I'll give you an abstract example. So because of records that police departments keep, how many calls have they made? How many other events that have required a public response? That's one set of facts that can be looked at. Certainly, what I'll call the anecdotal story of a neighbor coming in who says, this happened the other day, well, again, the body can give weight to that. If more than one neighbor comes in and makes a statement about an event, perhaps that's more credible under those circumstances. Again, it's a deliberation, it's a listening, it's a process. And I wouldn't get hung up on the details of this. I think that when I have observed in my years with the village, when council is considering something and when the planning commission is considering something, I have found those bodies to be extremely thoughtful and have gone through the adjudication process in an appropriate, lawful, respectful, and legal way in every way.
Well, I would not have a problem with it being conditional use. We did recommend that. But I guess I really want to see very minimal conditions put on it. You know, I went to the meeting that AJ and Canetta had, and, you know, I have read all these things on the internet about large cities, all the problems they have. And I was concerned about that. And that wasn't at all what I heard at that meeting. And Denise, you were at that meeting also. That what I heard is a number of the people who have, in fact, it seemed like most of them, who had the transient housing, had it for financial reasons, that they needed that income in order to continue to live in the village. That it was probably not necessarily an easy decision for them. It also sounded like they were bringing some wonderful people into town, that there were people who are coming to various events that are held in town. There was one young couple there that were from out of town, from Columbus. They were the only ones from out of town. And I know I talked to them in the hall, and they were really wonderful. And I think they'll probably move to Yellow Springs eventually, unless we scare them out with all of our regulations. I think that we need to be really cautious, because people also talked about, because I think it's anecdotal of people saying they're losing their housing. We need to really know factual what's going on, and not just listen to one particular story. That I think there are reasons why people lose affordable housing, and sometimes it's because of the kind of tenant they are. And I heard that and know, you know, of at least one person, that's the reason they chose, and that their transient guests take much better care of their property than long-term tenants. And so that seems like that's a decision that a property owner should be able to make, if, you know, if they need the income and if they see other reasons, why not? So I want us to be really cautious. When we were considering it before for conditional,
It was a conditional use.
it was very minimal what we
It
had.
was
In
very
fact,
minimal what we had, so we wanted to just match it up with the same conditions as the accessory dwelling unit.
and I know what the challenge was to be objective and
Yeah.
not to be subjective and say,
Right.
well, you know, we don't like, you know, da-da-da. You know, I think it's fine to listen to, and we should make the neighbors aware of it, because that was my initial concern. And my concern was more for people with children having, you know, strangers to the neighborhood. Well, that doesn't seem to be happening, nor do parents seem to have any concern about it. So I'm not sure that I should be the watchdog for all the kids.
Yeah, and I think that when I was at council meeting, I think they were just trying to revisit and maybe get ahead of something before it becomes a bigger issue down the road. I think they all recognized from the statistics that we're not there yet, but maybe we need to go back and put some regulations in. So if you want, I mean, I can come back with just, do you want to go with what we had approved at the planning commission level before?
I would like to see that again and decide if we want, you know, anything else in it.
Can we get a map and see where everybody is? Of where all the.
Are there zoning districts that seem to be disproportionately impacted?
Is it possible to get a map of?
For the 39 or what we have?
Sure, yeah.
You know, I certainly support returning it to conditional use. I would like to hear some discussion about, without, you know, I'm not saying I'm advocating for this or not, but limiting transit guest lodging permits to permanent residents. I'd like to hear some discussion about that, because I think that there is a fear, and to your point, that some of these fears are just, you know, vague sense of paranoia, or well, maybe. But this idea that outside investors could come in, our housing is expensive to us, but if you live in California, it's cheap, right? So, you know, this idea that there's a risk of outside investors. So I'm just wondering what the planning commission thinks about that.
may I ask a question, Lisa, which is, in your mind, does owner occupied mean the same thing as permanent residence?
No.
How do you make that, what's the
So
distinction?
to me, owner occupied is like, I live in a house and then I leave sometimes and let it be an Airbnb. Or I live in and I have an accessory dwelling. So that's all my space or my room, but to me, permits to permanent residence would mean, say, I have a house and I buy another house and I live in town and I turn that other house into transient guest lodging. But
So-
I am a permanent resident of Yellow Springs.
And therefore, I can have transient guest lodging investment that an outsider could not have.
Correct.
I think that would be problematic of the Constitution.
Oh darn.
That would be my gut reaction.
And I have to say, that was a concern that I had.
That would be an equal protection issue because you're treating people disparately.
And we had at the meeting, one couple who came who had a house that they use as transient housing. And they were a lovely couple. And it seemed to me that they're sort of testing out the village and may move here. And I wouldn't want to stop that,
Yeah, I see.
I mean, if that were something the planning commission would want to consider, I certainly would research it. But just my gut reaction is that would be very problematic and subject to challenge that I'm not sure would be.
And is there a
Upheld.
difficulty just even defining what a permanent resident is?
Could, but I think we could work our way around
Yeah,
So
it.
that's
but
this-
that would have to be,
law.
that would have
That's
to
this
be
fourth
defined.
suggestion here. I'm just going through your suggestions.
So, can you limit the number
The number of total units,
on a permanent resident?
I don't,
I mean,
That any one person can own, you mean? Or-
like
or
say,
that
if you're not owner occupied and you're a permanent resident, can you put a cap on the number of those transient guest
Of units you
lodging?
can have.
what I would
units you can
say
have.
is that it couldn't relate to the number an individual owns, but you would put a cap
Put a
at the
cap.
top.
For a certain district or an area?
Could, that's certainly been done.
And then would that be a potential category of conditional use?
So, yeah, so let me give you an example of how it could work and something I've seen loosely. Okay, let's take, we've got R, A, B, and C, right? So we could say, if you saw that there was, in this hypothetical, disparate impact on residential C because it's the highest density and that's where most of the investors were coming in, you could arguably say, within that zoning classification, you could place limits on that. You could outright ban it in certain places. I mean, that's what Columbus has done. They've said in these locations you can't have it at all. Or because residential A is less densely populated by definition of what it is, maybe there are no limitations there. Again, what I'm saying here is there are lots of ways we can get there. I think that you don't have enough data. I think that map would be important. I think that we ought to check with, to see if we can link any police calls or, public safety components to transient guest lodging. I haven't heard of any, but it doesn't mean that it isn't an issue. And I think that we're also hearing from this side of the table that there seems to be an appetite to visit this conditional use, but what criteria do we want to establish? And I think getting back to Dino's point, certainly in the context of a conditional use, factors that the Planning Commission will consider include the following, but it's not dispositive of the ultimate request. So that there's some, again, we can work our way through this.
I think it might be reasonable to consider a cap for the community as a whole. And I don't know what that would be. But I think if we have a map and see how many are in the areas, maybe we want to put a upper limit on the number of, and then see what happens. I mean, anything that we do can be changed.
Yes.
And so I would think, we're sort of just testing things.
Okay, by way of example, this was the best data that we had in December, which means it's probably extrapolated from September. Yeah, at that time, Yellow Springs had 34 Airbnb, well-known Airbnb units. Oxford, Ohio, had 69. Dayton had 174 on Airbnb, and then Columbus had 296. I haven't done any math, but I would suggest that based upon that math and the size of the village, that's a substantial
Pretty good
proportion.
Yeah, I agree.
And by the way, our research also showed that they were HomeAway, VRBO, which is one, FlipKey, Transit, TripAdvisor, Booking.com, in addition to the Airbnbs.
And often cross-listed, though.
Right.
Yeah.
The other thing we're gonna do too, we're gonna grandfather, obviously, everybody that's licensed now will be
Yes.
grandfathered, so would we look at adding above that, capping the 34 to 39, and then say above that is what we wanna start looking at as how much growth we're gonna get?
Yeah, I think that to withstand any potential legal challenge, one, I got a hard time thinking that there's gonna be a legal challenge that flows directly from the village when you have these big fights happening other places. But having rationale based upon empirical data is an important part of the
Yeah.
process, given what I'll call the complexity of this issue and the balancing of the issues you're trying to accommodate.
Okay.
So, yeah, I think,
No.
so generally going with the conditional,
Send an email.
starting with the criteria that were there before.
Yeah, I mean,
Starting
well, I
with the
mean, you know,
starting
like we said, we can just throw it out for discussion.
Yeah.
I mean, I just need to publicly notice for a hearing the actual section of the code,
Right.
but as far as, I mean, I can throw it in there and then we can dissect it. And then also, I'll bring a map showing the current locations and check on any police calls. And we may not want to do, we may not want to limit it as much as we had before.
Well, and I have a question, just because I'm not clear on it. So were you, when you're just considering the notion of capping, is that not owner occupied? Is that any unit at all? Or are you just throwing it out as, we're just going to have a discussion on capping, period?
I think discussion.
I think discussion, that was the impression I had. I
Okay.
think
Yeah.
Just,
Because from what was said, legally, we can't limit anyone out of town or in town from the number of units that they have.
Well, no, but you can differentiate between an owner-occupied, where the owner is present on the property, as differentiated from a standalone. And on that, you can legally do, right? Those are two completely different variables. If I set my Airbnb on fire, you are literally next door, and you know what is going on, and you can engage services, and you're present if there's an emergency situation. A standalone home where the owner is not present presents another set of variables to the community. So I do think it is apples and oranges, and I think they can be considered differently. Am I wrong?
Again, short answer is I think we can.
I mean, legally.
I think that we can, but again, devil's in the details. Let's find out what we have, and that will evolve.
as a starting point for a more detailed discussion.
Okay.
Does
All right, well, I'll publicly notice it and bring it back.
that sound good to everybody?
Yeah, and I'll just write a little bit for council so they know that this group was discussing conditional use with criteria, factors including density, zoning type, types of units, that there'll be a map and that it'll be noticed.
Okay.
You guys gonna take a public comment? We've been sitting here a while.
We usually have it after we talk anyway, so.
Yeah.
All right, sorry. Open the public comments.
Karen Wintrow. There's so much to say. I don't know where to start. The number of units, I mean, I'm just going to kind of be all over the board because I have so many perspectives of this. But the number of units and to think that there are a lot of units in Yellow Springs already, percentage-wise, we have a lot of visitors in Yellow Springs. And if those people aren't staying in Yellow Springs, they're staying in Beaver Creek or they're staying in Springfield. Us not having Airbnbs is not going to keep people from coming to Yellow Springs to visit. It will keep them from spending the night. It will keep them from eating breakfast, lunch, and dinner in Yellow Springs and staying and putting $100 to $200 in those transient lodging locations and paying lodging tax. So there is a significant financial impact that those Airbnbs bring. We're not, you know, I'm actually shocked that Dayton has 200. I'm like, why are all those people, especially with all the new hotels, I can't figure out why there are that many in Dayton. But anyway, so I wouldn't be quite as concerned about the numbers because that's going to even out. I mean, if people aren't staying, people, you know.
It's going to saturate.
It'll get saturated and it won't be an issue. You know, I do think that the conditional use, I didn't think it was on council when it was decided, or when I was on council when it was decided that it wasn't going to be conditional anymore, and I thought that was a mistake. I think the neighbors absolutely have a right to know what's happening. I think that's the control point. I think having a map is good. I would like to see it. I probably could make that map. You know, they go on and off very quickly. I mean, one of the ones you have on your list that has an out-of-town owner, I know those people are moving back into town, and so theirs will be off the transient lodging list. Another one of the transient lodging, people are here half the time, and they're in California half the time. You know, the Columbus couple, I agree with you completely. They come here for the weekend when they have an opening. I believe that they probably will move here. It isn't an incredibly lucrative business to be in. So the idea that somebody's going to come into town and buy up a ton of houses, you know, it's not like New York where you could buy up a building and turn that building, Airbnb that building, that could make some financial sense. Doesn't make a lot of financial sense to have a bunch of houses scattered all over town when you don't live here, because the management and maintenance of them, it doesn't make math. And I mean, you guys really do have to get some real facts about, instead of the anecdotal thing of, you know, there was just something said that somebody said that they had 4 Airbnbs on their street. I don't think that there are 4 Airbnbs on any street. Maybe on Winter Street, where Bob Swaney has a few. But there are too many anecdotal comments. There are too many things, well, this is what happened in Cleveland, or this is what happened in Columbus. None of those things have been happening in Yellow Springs, and I think generally it has been a real positive. You know, for artists, for the wellness community to be able to have more people come and stay in Yellow Springs for wedding receptions and big events. I think that I'm not yet convinced that we're at a point that we need to restrict the numbers. I think we need to be aware. I think you guys are on the right track.
Yeah, and I think
You're
that'll be
absolutely on the
value
right
of
track
having
about that.
the report
And-
come back and have a better
Exactly.
and more factually based discussion.
Yeah.
Yeah. So, okay, thank you. Any other public comments?
Well, I
Nope.
guess maybe I should just stand up. You know,
Yeah,
some of
just
these-
state your name, please.
Yeah, my name is Eric Clark, and I've lived in town 56 years now. And, you know, at the meeting that we had, I did discuss that the idea of transient lodging is nothing new to the village. Because even as a child, I recall in the 70s, my parents always had the opportunity to rent out a room in the house for incoming faculty members of ENIAC, for Shakespeare festivals, et cetera. And now I'm finding that since I've had my unit open for about 5 years, I guess, that's the best guess, that I do get an awful lot of people who stay there because there is a very limited number of places to stay. And we always think of street fair, we think of the yoga retreats and et cetera. But I want you to remember also Friends Care Center. They don't have a Ronald McDonald House for housing of the people that need to stay for an extended period of time. I want you to think about how big Cedarville University is. And now think of how many rooms they have there. They have that one small hotel. It's very nice, but it doesn't accommodate nearly what they need. So we end up with an awful lot of housing for the Cedarville community. Right now, I have some people that are staying for about 3 weeks because they just bought a fixer-upper over on Whiteman Street. And so they will be moving into town. And I'm glad that they're staying here in town instead of staying someplace else. When I used to own the motel, I used to remind people that if somebody stayed for a night, they would come into town, have dinner the next morning, have my really crummy breakfast that I offered, and they would go on home. If they came and they stayed for 2 nights, they'd come into town, have dinner, have my really crummy breakfast, but then they would eat lunch, and they would eat dinner, they would stay another night, and they would eat a better breakfast the next day. And in between there, they did an awful lot of shopping, and I can guarantee how much shopping they did by the number of bags and everything that I had in the trash. So I think it's important that we don't discount that possibility that we just simply don't have enough rooms for all the people that want to come and be a part of our village. And although we have a lot of people in town that want to be, what I will just say, wall builders, because they aren't from 45387, and they like to call them dirty words like tourists and such, they are not. These are people that love us, and that's why they're here. And they aren't looking to stay at a Quality Inn or a Comfort Inn. These people come to Yellow Springs because they want an experience. And bed and breakfast type lodging is the new way to go. It is the experience. Staying with a host family, driving in an Uber. They don't want a taxi, they want to get in a car with somebody and talk to them for wherever they're going. This is just the new economy. And you can call it a shared economy or whatever, but pretty soon, folks, we're going to be renting out our power tools to people that want to borrow them on the same type of system. And so we need to be prepared for that. And I won't bring up some of the other things because it looks like you're not going to go into the heavy rules and legislation right now. But there'd be a few other things I'd want you to consider.
Public notice for the next time we discuss it.
What?
There'll be,
Oh, yeah,
Yeah.
yeah, absolutely.
This may sound peculiar, but for the people who are here for the long haul,
You're not gonna get
I want to just give the possibility of these permits to be something you can inherit, that would be passed along if you had a TOD on your property, or you were assigning your properties to your children, because my properties are not for sale. And I'm hoping that my 2 kids will get the 2 properties that I have. That has always been the goal. I don't intend on making a single penny off of my properties. They will go to them. And they are probably going to need to pay some pretty hefty utility bills, I suspect, in the next 10 years. So I'd like to have them the opportunity without having to get on a wait list to start over again. It's just my thought. So anyway, thank you very much. I do want to tell you that I really appreciate all the work that everybody has done here, okay? Thank you.
thank you. Public comments, I guess we'll close the public comments then. All right, so we're done with that. Okay, and we've got we don't have, no new business. And we have the agenda planning done. We've gotten through. Yes?
No,
No.
I was going to move.
No, you're gonna move, we adjourn? Go ahead.
Are we ready?
Yeah,
Okay, I move we adjourn.
Second.
it's been moved in second that we adjourn. All in favor, say aye. Aye. All opposed, nay. Thank you very much, and thank you very much for coming. Sorry to make you wait so long.
You're doing a great job keeping us on